Hi, my name is Scott Harn. I'm the editor and publisher of ICMJ's Prospecting and Mining Journal. We've been around for about 85 years now, reporting on all things related to mining. This is a joint presentation between us, the Minerals and Mining Advisory Council, and Public Lands for the People. And what I want to talk to you about is the power of mining districts, restoring access and returning to reasonable regulation. So we got to ask ourselves, how did we go from this, a miner reporting directly to his mining district, to this? Currently the miner has to deal with countless state, local, county, and federal agencies that all want to have a say in how you operate. So we're going to start off with a little history. Back on January 24th of 1848, you had the gold discovery by James Marshall on the American River while constructing Sutter's Mill in California. February 2nd, 1848, the Treaty of Guadalupe Hidalgo was signed. It ended the Mexican-American War. And less than 2 weeks after that, Colonel Mason, he was the commander of the American military forces, signed a decree which stated Mexican laws and customs now prevailing in California are hereby abolished. Well, those were the only laws in place at that time. And you're talking about a huge area. You have California, Nevada, Arizona, Utah, a huge area of the western United States that was involved in this agreement. You also had miners pouring into the area. In June of 1848, there were an estimated 4,000 to 5,000 of them. By the end of 1849, 40,000 miners estimated in the area. And by the end of 1852, just 3 years later, 100,000 miners were estimated in the area. And here's a picture of Hangtown, otherwise known as Placerville, California, from 1849. And all that infrastructure pretty much was established within a year. So the miners, basically out of necessity, became self-regulating. They were able to create order out of chaos. The concept of a claim became standard around 1849. Basic rules became widely accepted within months, and as an example, tools that were left in a hole indicated the miner was still actively mining. Soon after, the miners met to lay out rules for geographic areas, and the mining district was born. The right of first possession was accepted for who gets a particular area, and there was a requirement that a claim must be worked to maintain possession, and that became common across all the mining districts. The districts evolved and rules were set by the miners regarding claim size, marking and staking, the number of claims allowed, forfeiture, and arbitration. And Congress got into the act. It was led by a guy by the name of William Stewart. He was studying to be an attorney out east, and he came out to California to see if he could strike it rich. He didn't fare too well, and he went back to law school and finished his degree. He's your primary author of the Lode Law of 1866, which addressed lode deposits, and of the Placer Act of 1870. And that was meant to fill the gap after the Lode Law failed to address placer deposits. These two laws were merged into what is commonly referred to as the General Mining Law of 1872, or the 1872 Mining Act. And again, the miners did such a good job that Congress adopted most of their rules and regulations when it created the 1872 Mining Act. The mining law allows us to explore for minerals and establish rights to federal lands without authorization from any government agency, and this provision, known as self-initiation or free access, is the cornerstone of the mining law and remains in effect today. The Act stated that all valuable mineral deposits and lands belonging to the United States, both surveyed and unsurveyed, shall be free and open to exploration and purchase, and the lands in which they are found to occupation and purchase, by citizens of the United States and those who have declared their intention to become such, under regulations prescribed by law, and according to the local customs or rules of miners in the several mining districts, so far as the same are applicable and not inconsistent with the laws of the United States. Let's talk about a few other significant developments along the way. You had the Antiquities Act, 1906, in which Congress gave the President of the United States the authority, by proclamation, to protect objects of historic and scientific interest. It was initially passed to protect Indian ruins and artifacts in New Mexico. But it didn't take long for Roosevelt to use it for other purposes. He created the Devil's Tower National Monument in September 1906, and the Grand Canyon National Monument in November 1908. The Antiquities Act has been used over 100 times, including 19 times by President Clinton, 5 times by President George W. Bush, and 15 times so far by President Obama. In 1953, California passes a law that forbids the creation of new mining districts, but previously existing mining districts are grandfathered in. 1955, the Surface Mining Act. It stated that mining claims shall not be used for any purposes other than prospecting, mining, or processing operations and mining-related purposes. Any use of the surface of any such mining claim by the United States, its permittees, or licensees shall be such as not to endanger or materially interfere with prospecting, mining, or processing operations, or uses reasonably incident thereto. In other words, other public land users cannot interfere with your operation. Along came the Minerals Policy Act, 1970, in which Congress declared it's the continuing policy of the federal government in the national interest to foster and encourage private enterprise in the development of economically sound and stable domestic mining, minerals, metal, and mineral reclamation industries. 1972, the Clean Water Act. EPA and the Army Corps of Engineers were granted the authority to regulate navigable waters. 1990s, EPA and the Army Corps tried to take control of non-navigable waters. In 2001, the Supreme Court ruled that the Army Corps had no authority to assert control over isolated bodies of water. And in 2006, the Supreme Court ruled the EPA did not have authority over a wetland that was near a ditch that eventually drained to a navigable water. 76, you have FLPMA, the Federal Land Policy and Management Act. It allowed for the establishment of wilderness study areas. Key provision stated that the public lands be managed in a manner which recognizes the nation's need for domestic sources of minerals, food, timber, and fiber from the public lands, including implementation of the Mining and Minerals Policy Act of 1970. Again, that act stated, and it's in the national interest to foster and encourage mining. So a few questions we need to ask. What are we doing wrong? Well, first off, we've allowed mining districts, which are federally recognized entities, to fall into disarray. We participated in negotiations that we couldn't win. We settled for providing comments rather than asking for a level playing field and a seat at the table. And I'm going to give you an example here. The first example is suction dredging. Most, if not all of you, probably already know what happened with that. Yet members of the Karuk tribe teamed up with the Sierra Fund to challenge the rights of suction gold dredgers in California back in 2004. They sued the Forest Service. Miners joined the Forest Service opinion that no plan of operation was required, and the miners and the Forest Service prevailed. Then the tribe sued the California Department of Fish and Game. This time they chose Alameda Superior Court. At the last minute, the miners learned of this suit and that Fish and Game was prepared to sign a settlement, and the miners intervened. Despite an overwhelming number of studies showing that suction dredging has an insignificant impact on the environment, otherwise known as de minimis, and actually provides many benefits, Fish and Wildlife changed their long-standing de minimis opinion. They said they had new evidence that dredging may be harmful to coho salmon. The miners prevailed, but the court ordered the California Department of Fish and Game to complete a new environmental impact statement on suction dredging. And then Fish and Game started dragging their feet. It didn't start the court-ordered process, despite the order, and the dredgers were patiently waiting for permits to be issued again, and are still waiting to this day. Along the way, you had two retired EPA scientists who came forward. Their names were Joseph Green and Claudia Wise. They said they left the agency when it refused to publish their study that found the effects of suction gold dredging on the environment were not only de minimis, but that suction gold dredging is actually beneficial to fish and invertebrates. Fish and Game eventually began taking public comments and holding scoping meetings. And nearly every major study supported the position that dredging is insignificant, except for a single study completed by a member of the U.S. Geological Survey, who also happens to be a Sierra Fund board advisor. In the meantime, you had a legislator introducing another bill written by the Sierra Fund to stop all dredging in California. And Schwarzenegger asked us at the Mining Journal, along with two other groups, to complete an economic impact statement on suction gold dredging in California, and also asked for scientific studies for and against suction dredging, which we provided. The economic impact was measured in excess of $100 million per year when all expenditures are taken into account by miners. So the bill was vetoed by Governor Schwarzenegger, and he labeled it unnecessary. Keep in mind that we already had a full set of regulations in effect to keep dredgers out of the water when any reds were present, and to keep them from interfering with any spawning seasons. Yet another bill was introduced to stop suction dredging, this time by a legislator in Malibu. There are 0 mining claims in Malibu, and this guy admittedly had never been to a mining claim or operation. And just prior to leaving office, Schwarzenegger signs that bill with no explanation given. That was the beginning of the lawsuits. The miners had to sue to try and restore their rights. After several years of hearings, briefings, delays, a judge rules in favor of the miners. He calls out the state of California for running what he labeled a permitting scheme. The state appeals, and the case is now on hold until a decision is made by the California Supreme Court in a related case. That related case is People versus Reinhardt, and it's based on whether state laws can preempt federal laws. So kind of in summary here, the Army Corps continuously held the position that the impact of suction dredge of 6 inches or less is de minimis or insignificant. You already have court rulings in our favor that state the material that comes out of a sluice box at the end of a dredge is considered incidental fallback, not considered a discharge. And this was decided in court. And you can take a look at the article we titled "What is Incidental Fallback?" in our December 2015 issue for a complete review of the favorable court rulings that back up the determination. We all know that miners have rights granted under the 1872 Mining Act. It's federal mining law, and this cannot be preempted by state law. Federal and state agencies can require some mitigation of activities according to the Ninth Circuit, but cannot unreasonably prohibit, hinder, or clash with the miner's right to mine. Many of you probably are not aware of this, but miners are not subject to agency discretionary action unless they consent to such action. In other words, if you consent to obtaining a permit by labeling yourself as a recreational dredger rather than a miner, you are subject to the permitting scheme put forth by your state. If you are dredging a valuable deposit or attempting to locate a valuable deposit as a sole source of income or to supplement your income, you are by no means recreational, and please stop calling yourself recreational. For more on this topic, you can take a look at What is a Mining Right, which appeared in our April 2015 issue. We also know the power of mining districts is written into the 1872 Mining Act. A mining district has the ability to create rules and regulations, and it puts miners on a level playing field with state and federal agencies. Another short example of negotiations we can't win deals with the EPA. In 2014, they proposed a new rule regarding waters of the United States, or WOTUS. They have tried it before and failed. They wanted to change the definition to control ponds, ditches, seasonal waters beyond the traditional navigable waterways. In August of 2015, a federal judge in North Dakota blocked the new rule with a temporary injunction after a lawsuit was brought by 18 states. So the EPA goes on to say that the injunction doesn't apply to the remaining states who weren't a part of that lawsuit. So other states filed suit against the federal government over the same issue, and then the judge blocked the EPA from redefining the definition in every state until it could be heard in court. During the supposed rulemaking process here, the EPA claimed that 87% of approximately 1 million comments received were in favor of the new WOTUS definition. But during a hearing in front of the House Committee on Natural Resources, it's revealed that the EPA partnered with the Sierra Club and other environmental groups to send in favorable comments. It's also revealed that only 2% of the comments received during this process were unique. If we removed the form letters and emails sent by environmental groups, it's revealed that 61% of the unique comments were actually against the rule. So how do we as miners respond? Well, because of these unlawful actions by state and federal agencies, we are advising our readers to serve state and federal agencies, for example, Fish and Wildlife, the Forest Service, BLM, with what's called a direct and constructive notice until they get their mining districts in order. A direct and constructive notice is the first step in the process to allow an individual to sue a government employee personally for knowingly violating your rights. How do mining districts work? We have these tools, remember. The Minerals Policy Act of 1970 says it is the continuing policy of the federal government in the national interest to foster and encourage mining and mineral development on public lands. And the 1872 Mining Act, which includes the words, according to the local customs or rules of miners in the several mining districts. There are literally thousands of mining districts across the United States, and you'll find them in, I believe, 19 different states where public lands are available. But for the purposes of our discussion here, we're going to focus on California. Virtually anywhere in California where a valuable mineral deposit has been found, a mining district was established. Here's a map of California showing all the mining districts. This is courtesy of westernmininghistory.com. So every single little dot on that map is a traditional mining district. There were 141 of them in California by the time California became a state in September of 1850. There were over 500 mining districts in California by 1866. Let's zoom in on a section. So this is a close-up. It shows Coloma about in the center there where Sutter's Mill is located. This area depicted on this close-up portion is about 75 by 75 miles. And just within this area there were 88 mining districts. Districts are small geographic areas. Some of them are less than a few square miles. Each mining district has an elected board made up of claim holders working within this specific geographic area. Each district has their own rules and regulations, though they've always been very similar in nature. And any rules and regulations set conform with federal law. And the goal is for each district to seek and obtain a memorandum of understanding with the appropriate federal land management agency in their area. So remember, we have our current structure. Basically chaos. A miner trying to deal with countless different agencies who all want to tell them how to do their job. This is our proposed new structure. It returns to where the miner reports to his mining district, and that district is on a level playing field with the Bureau of Land Management. Off to the left you see the Minerals and Mining Advisory Council, which is just that. It's an advisory council position to help out. And a little more on what is the Minerals and Mining Advisory Council. They're made up of a group of elected miners chosen by their peers to assist other miners who wish to get their mining districts organized again if needed. That's it, nothing more. They're there to help. And we here at ICMJ's Prospecting and Mining Journal have been assisting those districts that are in disarray by publishing a public meeting notice, if needed, for districts that need help, and many have already taken us up on this offer. Here's a public notice we recently published for the Slate Creek Mining District up in Washington State. They were originally established in 1894. They're holding a meeting to elect board members and get their district out of disarray. I want to tell you about a recent field trip, for lack of a better term, made by Clark Pearson. He's the Northern Director for Public Lands for the People, and Joe Martori, the founder of the Minerals and Mining Advisory Council. They headed off to Washington, D.C. During a one-week period, they had over 36 meetings with legislators in the House and the Senate. They found that these guys were extremely supportive of miners. They were very frustrated at the lack of access to public lands, including the recent travel management plans put forth by the Forest Service. They all agreed that mineral and metal development is a national security issue. And these guys spent a lot of time educating legislators on the power of mining districts and what mining districts can do to put things back in order. One of the things they spoke about was the large bill that we had been working on for quite some time. I think we were on revision 40 some odd by the time these guys headed off to Washington. Anyway, the bill was titled the Minerals and Mining Regulatory Reform Act, a clear path respecting mining rights. It's a comprehensive bill that addresses numerous issues that miners face, both small and large scale. But what they found is during these meetings, such as this one with the House Oversight Committee, is that these guys, although they're supportive of the overall bill, they want to get something through now to show not only their commitment but their support to their constituents. You have to remember this is it's an election year 2016. So the bill that is currently being worked on is not really a bill per se. It's going to be offered as an amendment to an existing bill, but it's to take care of some of the major issues that we miners face. And these issues were also discussed with the House Resources Committee Chairman Bob Bishop. And we'll get into some more specifics here. But first I want to talk about this meeting. It was a BLM Desert Advisory Council meeting in March 2016. Again, Clark was there and Joe was there. I did a presentation as well by PowerPoint because I couldn't be there personally. And about 50 people were present, including environmentalists, BLM officials, attorneys, etc., including the Corva, or California Off-Road Vehicle Association, president. That's a group that we've been trying to get on board here for quite some time. They've been screwed over countless times in negotiations. When they enter these negotiations with the state, they give up quite a few rights. And every time their usable area gets smaller and smaller and smaller. They tried to negotiate with Senator Feinstein before the 3 national monument areas were declared by Obama in Southern California. But because Feinstein's bill did not go anywhere and these national monuments were made by proclamation, all the negotiations went out the window and Corva was left in the dust. So what's our current status? Well, we've been working with members of Congress on changes to formally recognize the power of mining districts. And this is to provide access to previously closed areas, to restore mining as a priority for public lands, reestablish mining districts as the arbiters of reasonable regulation, and to put all miners back to work, including suction gold dredgers. So you might be asking yourself, what can I do? Well, the most important thing is to get your mining district organized if it's in disarray. Like I mentioned before, it's not going to come out as its own freestanding bill at this point, at least not the first portion of what we've been working on. It'll be offered as an amendment and inserted into another bill. If you have your mining district in order, you're going to be a long ways ahead in this game. So you need to find out the name of the traditional mining district where your claims are located. Again, the traditional mining district, because in California, and it may be the case in other states as well, they passed a law that forbid the creation of new mining districts. You need to track down the original bylaws. And if you want to take a look at our site at ICMJ.com, under the Resources tab, you'll find a document titled Bylaws for Traditional Mining Districts. We have compiled already about 180 to 190 of these bylaws. There are lots of other places to look: mining museums, historical societies, your county recorder's office, libraries, lots of options, including on the internet. You'll need to attempt to contact the other claim holders, because you'll need 5 claim holders to make a quorum. Set up a meeting time and place. Publish a public notice, and we here at ICMJ's Prospecting and Mining Journal have taken on that role. We are doing that for free for you. All you have to do is send us the information you published, including the date, time, location, and the name of the district and where it's located. Then you can conduct your meeting and elect officers. The next step would be to securely post signage at all major entry points to your mining district. And then to start attending these oversight meetings for the public agencies in your area. While we're still working on this legislatively, we will have to still deal with the situation as it currently presents itself, and that is dealing with these unelected boards. And lastly, if you could encourage other mining districts in your area to get organized. Imagine going to one of these oversight board meetings and requesting and obtaining a seat on the board. But imagine if you could do that along with 10 other mining districts within that geographic area. It wouldn't be long before your votes would outnumber the votes of the others that are on this particular board. And lastly, I want to urge you to continue your support for Public Lands for the People so we can send these guys to Washington, D.C. on a more frequent basis. As I mentioned previously, the welcome they received was overwhelming, and they were actually quite surprised that many of these legislators have the same frustrations that we do, and they were more than willing to help. They have asked PLP, Clark, and Joe from MMAC to come back on a more frequent basis to help them write some of these bills, which will benefit all of us. So again, my name is Scott Harn. I'm the editor and publisher of ICMJ's Prospecting and Mining Journal. Our website is www.icmj.com, and we will attempt to keep you updated on these developments on our site and, of course, always in our monthly magazine. My email, if you have questions, is editor@icmj.com, or I can be reached by phone at 831-479-1500. Again, I want to thank you for your time in watching this, and this has been a joint effort of the Minerals and Mining Advisory Council, Public Lands for the People, and ICMJ's Prospecting and Mining Journal.